A private placement offering, or PPO, is a securities offering to a small group of investors instead of offering it to the public. This isn't to be confused with an IPO, even though both an IPO and PPO are securities offerings. Here we can see the differences between a PPO and an IPO. PPOs are cheaper and less time-consuming than IPOs because there's no underwriter involved. PPOs also have the advantage of being able to handpick investors, which allows the business to seek investors with similar goals to theirs. The more synergy there is, the fewer changes will be made. Unfortunately, PPOs are generally associated with selling the securities at a discount because of the illiquidity of the investment. An IPO is essentially the opposite, being more expensive and time-consuming, but being able to charge higher prices because there is a wider market to sell the securities to. A private placement memorandum, or PPM, is a complex document that has all the information needed for an investor to form a basic understanding of the offering. The PPM is usually lengthy and is broken down into sections. The first section an investor will come across is the introduction. It is pretty self-explanatory, but it includes information such as company name, offering type, time horizon, cost, and other similar information. Next are the basic disclosures that enumerate the risks that may be involved with the investment, including tax, legal, market, and competitive risks. In this section, a prospective investor would also find the use of proceeds statement that details exactly how the firm plans on using the funds to generate a return. The legal agreement delves into the execution of the idea. It includes which accounting methods will be used, the rights of the investors, how investors will realize their return, and other similar information. The term sheet is the final agreement between the two parties and includes details of the transaction. Due diligence is simply the investigation of a potential investment. With a PPM usually comes a due diligence checklist, even though many investors have their own process. The checklist includes all things the investor should consider, from the mission statement to financial statements and management team to pending legislation that may affect the firm. Now back to the term sheet we just briefly touched upon. This sheet summarizes the entire transaction and has sections of its own. The offering terms are the logistical aspects of the deal, including offering date, securities prices, and investors' names. The charter establishes legal rights of both parties and hashes out issues such as dividend information, voting rights for investors, protective covenants, and conversion details if it applies. Some other sections include the stock purchase agreement, which places certain conditions on the deal, the rights agreement that may include a right of first refusal, and the voting agreement that establishes how voting will proceed. Regulation D is a list of exemptions for securities offerings that don't need to be registered with the SEC. Rule 504 exempts any offerings under $1 million in a 12-month period as long as the company isn't a blank check company. Blank check companies are those without a detailed business plan that are speculatively hoping to merge with another firm. Rule 505 states a company can only raise $5 million in 12 months with offerings to an unlimited number of accredited investors and only 35 non-accredited investors. Investors must also be aware that they are purchasing restricted securities that restrict them from being sold within 6 months if they aren't registered with the SEC. Rule 506 includes all of what Rule 505 does, but the definition of non-accredited investor is much more stringent and requires the investor to have some business and finance experience, if not expertise. Under Rule 506, the company can also decide what information to give to accredited investors as long as they are not fraudulent, but they must give all disclosures to non-accredited investors. The company also has to be willing to answer any questions any of the investors may have. This section talked a lot about accredited investors, and an accredited investor is essentially either a rich person, a bank, or an investment firm. Now wrapping it all up, a PPM is a complex document that includes the bulk of the investment information. Due diligence is the deeper investigation of an investment, and in this case, the PPM provides investors with a due diligence checklist. The term sheet outlines the details of the deal and can often work as the written contract itself. And finally, regulations can provide exemptions for many of the PPOs, but there are many rules that must be followed.